Imagine you're standing in the airport security line. Your shoes are off, your bag is open, your phone is in a gray bin sliding toward the X-ray machine. Then an officer pulls the bin aside and says they need to take a closer look. In that moment, most people have the same thought. Can they actually search my phone, or do I have a right to say no? What makes this so confusing is that the real answer is not a simple yes or no. It depends on who is asking, where you are in the airport, and what kind of search we are talking about. There's a huge legal difference between screening the physical phone as an object and searching the digital life stored inside it. And there's also a huge difference between a routine TSA checkpoint for a domestic flight and an inspection by Customs and Border Protection when you are entering or leaving the United States. That difference matters because a lot of people use the name TSA to describe any federal officer they meet at an airport. But airports are not one legal zone with one set of rules. A domestic security checkpoint is one thing, an international arrivals hall is another, a customs inspection area is another, local police at the airport are another. If you mix those together, you can end up badly misunderstanding your rights. So let's clear it up in plain English. If you are talking about ordinary TSA screening at a regular airport checkpoint, the government's published rules focus on aviation safety. TSA says electronics larger than a cell phone may need to be removed from your bag for separate screening. And its public guidance also says officers may ask travelers to power on electronic devices. That tells you what TSA is mainly doing at the checkpoint. Checking whether the device is a threat item, not treating the checkpoint like a general criminal investigation into your private data. That is the first key point. There's a major difference between a phone being screened and a phone's contents being searched. An officer looking at the phone as a physical object is not the same thing as an officer reading your texts, opening your photos, or scrolling through your apps. People often hear stories about phone searches at the airport and assume the TSA checkpoint itself works like a roadside police stop or like customs at the border. Usually, that is not the right way to think about it. Now, notice that I said usually. If your phone cannot power on when asked, that can become a problem for travel. If the device looks suspicious as an object, or if something about your screening turns into a law enforcement issue, your airport experience can change fast. But that still does not mean every officer at every checkpoint has the same authority to dig through your digital information. Here is where many people get confused. The most aggressive phone search stories in airports often involve Customs and Border Protection, not routine TSA screening. And CBP operates under a very different legal theory called the border search exception. That matters even if you are physically standing in the same airport building, because the law treats the border and the area around a port of entry differently from an ordinary domestic security line. So imagine a second situation. You just landed in the United States after an international trip. You go through passport control. An officer refers you to secondary inspection. You're tired, jet-lagged, and now someone asks about your phone. That situation is legally very different from a normal TSA line before a domestic flight to Denver or Atlanta. CBP's own public guidance says officers may search electronic devices at the border or port of entry, and that includes phones, laptops, cameras, and other digital devices. CBP also says those searches are relatively rare compared with total traveler volume. In fiscal year 2025, CBP says it processed more than 419 million travelers at ports of entry and searched the electronic devices of 55,318 international travelers. So the odds are low. But low odds do not mean low stakes. If it happens to you, it becomes the only number you care about. There's another detail that often gets overlooked. Being sent to secondary inspection does not automatically mean your phone will be searched. CBP says a border search of electronics is not a required part of secondary inspection. In other words, secondary can happen for many reasons. A document issue, a random screening, a question about your travel history, a name match, a customs concern. A border officer has broad discretion to ask more questions without first having the kind of suspicion police usually need in ordinary criminal cases. That leads to the next important distinction: basic searches and advanced searches. Under CBP's current directive, a basic search is essentially a manual review of information that is already on the device. Think of an officer physically handling the phone and looking through material stored there. By contrast, an advanced search is when officers connect external equipment to the device to copy or analyze its contents. That is the deeper kind of search people worry about when they hear the word forensic. Why does that distinction matter? Because CBP's own policy draws a line between the two. A basic search can be done with or without suspicion. An advanced search, according to CBP's directive, requires reasonable suspicion of activity violating laws enforced or administered by CBP, or a national security concern. That does not mean everyone agrees the Constitution is fully satisfied by that policy, but it does mean the government itself recognizes that a deeper search needs more justification than a simple manual one. And here's a detail many travelers would never guess. CBP's directive says officers are not supposed to intentionally use your device to access information that is stored only remotely. In plain English, they are not supposed to intentionally reach into your cloud account just because the phone can connect to the internet. The policy says officers should disconnect the device from a network, such as by using airplane mode before reviewing it. That is not a magic privacy shield, but it is a meaningful limit in the written policy. Now, let's talk about the question almost everyone asks next. What if they want your password? This is the point where the legal and practical answers start pulling apart. Legally, the answer is not identical for every person or every circumstance. Practically, the situation can turn ugly even when you're trying to protect your rights. Civil liberties groups like the ACLU warn that for U.S. citizens, refusing to unlock a device should not mean being denied re-entry into the country, but it can still mean a longer detention or a device seizure. For non-citizens, the practical risks can be greater, because entry into the country can depend on immigration status and officer decisions in ways that simply do not apply to a returning U.S. citizen. That is one reason airport advice on this issue often feels unsatisfying. People want a movie-style line they can say, and then everything ends cleanly. Real life is messier. You may be legally right about one issue and still lose time, lose access to your device for days, or spend hours in secondary inspection. Rights matter, but so do consequences. If you do decide to unlock a phone in a border setting, one commonly suggested practical step is to enter the password yourself rather than speak it aloud. The reason is simple. Once you hand over the actual password, you lose control over who knows it. The ACLU has recommended that travelers who choose to comply at least enter the password themselves and change it afterward. That is practical advice, not a guarantee of safety, but it reflects how digital privacy works in the real world. But that is only part of the story. A lot of people assume the border rules mean police can search a phone anywhere, anytime, as long as they grab it during an arrest. That is not true. Outside the border setting, the Supreme Court's decision in Riley v. California is one of the most important phone privacy cases in modern American law. The court said police generally must get a warrant before searching the digital contents of a cell phone seized from an arrested person. The reason was not technical, it was common sense. Modern phones hold an enormous amount of private information about nearly every part of life. That is why the airport question is so tricky. In an ordinary criminal case, the law strongly recognizes that your phone is not just another pocket item. It is more like a portable archive of your life. But at the border, the government argues it has broader inspection authority. Courts have not produced one simple national rule that eliminates all doubt. Lower courts have reached different conclusions on how much suspicion is needed, especially for more invasive digital searches. And the Supreme Court has not yet given a final, across-the-board answer on border phone searches the way it did in Riley for searches incident to arrest. So if you have ever heard two confident people say opposite things about airport phone searches, that may be why. One person is thinking about ordinary police rules. The other is thinking about border rules. Both may sound certain, but they are talking about different legal settings. Now let's bring this back to the title question. Can TSA search your phone at the airport? If by search your phone you mean physically screen the device as part of airport security, yes, TSA can inspect the device as an item going through security. TSA's public guidance makes clear that electronics are screened, larger devices may need to come out of your bag, and officers may ask that a device be powered on. That is normal checkpoint authority tied to transportation security. If by search your phone you mean open up your digital life and start reading through your messages, photos, and apps as part of ordinary domestic checkpoint screening, that is a very different question, and it is not what TSA's public checkpoint guidance is built around. The bigger, better documented legal risk for digital content searches at airports comes from CBP in the border context, not from routine domestic TSA screening. That distinction alone can save people from a lot of confusion. Suppose you are flying from Chicago to Phoenix on a domestic trip. You go through TSA, your phone gets screened. Maybe an officer asks you to move it, separate it, or power it on. That is one legal world. Now suppose you are returning from London, Dubai, or Mexico City and entering the United States. You meet CBP. You may be sent to secondary. Questions about your device now fall into a different legal world. Same airport, different agency, different rules, different risks. There is another mistake people make here. They assume that if a search is rare, they do not need to think about it. But part of being informed is understanding low probability, high impact events. Most people will never have their phone searched by CBP. CBP's own numbers show that clearly. But if you carry privileged business files, sensitive source material, private family information, medical data, or confidential work communications, even a small risk can matter a lot. So what should an ordinary traveler remember before walking into the airport? First, know whether your trip is domestic or international. That sounds obvious, but it changes everything. The strongest routine phone content search risk is generally tied to border entry or exit, not the average domestic TSA line. Second, keep your device charged. That may sound almost silly after all this constitutional talk, but it is practical. TSA publicly says officers may ask travelers to power on electronic devices. A dead device can create an avoidable problem at the checkpoint, even when nobody is trying to look through your personal data. Third, understand who is talking to you. Is it TSA? Is it CBP? Is it local airport police? Is it a federal law enforcement officer outside the screening process? Those are not interchangeable roles. If you do not know which agency is asking for access to your device, you do not really know what legal situation you are in. Fourth, stay calm and do not lie. People sometimes focus so much on asserting rights that they forget basic survival rules for stressful encounters. You do not want to turn a tense inspection into a separate problem by giving false statements or physically resisting. Calm questions are usually smarter than dramatic speeches. Fifth, if you are in an international border setting and privacy is a real concern, think ahead before the trip, rather than improvising in secondary inspection. That does not mean destroying evidence or playing games. It means understanding what sensitive information you carry, what your workplace policies are, whether you travel with privileged or confidential material, and whether you should get legal advice before an important international trip. For some people, especially journalists, lawyers, executives, researchers, and people handling protected client information, that planning matters. Here's where many viewers want a clean, universal script for what to say. Something like, I know my rights, you need a warrant. The problem is that line may fit one legal setting and badly misfit another. If local police arrest you on an ordinary criminal matter and want to go through your phone, Riley is a major part of that conversation. If CBP is questioning you at a port of entry, the government is operating under a border search framework and the analysis changes. That does not mean you have no rights at the border. It means your rights are more complicated, and the consequences of pushing back can be different. For example, if you are a U.S. citizen returning home, the ACLU notes that you cannot simply be refused re-entry for declining to unlock a device. But that does not end the matter. You may be delayed. Your phone may be seized. The trip you thought was over may suddenly become much longer. If you're not a citizen, the pressure can be even more intense because the legal and practical stakes of entry decisions are different. There's also a timing issue people rarely think about. If CBP takes custody of a device, the matter may not end at the airport counter. Under CBP's current directive, detention of a device ordinarily should not exceed 5 calendar days unless there are extenuating circumstances or approved extensions. The directive also says copies of information generally should not be retained beyond 21 days after the search ends, unless retention is otherwise permitted or required. That does not make the experience harmless, but it does show that the written policy includes time limits and handling rules many travelers never hear about. And that brings us to a myth that needs to die. If you have nothing to hide, just let them look. That phrase sounds simple, but it ignores what a smartphone actually is. A phone is not just a phone. It can contain your financial history, health data, private conversations, photos of your children, personal notes, work product, legal communications, travel history, contacts, and access to other accounts. You do not need to be guilty of anything to care about that. Privacy is not evidence of wrongdoing. It is part of normal adult life. Another myth is that this only matters to celebrities, activists, or people on watch lists. Not true. Sometimes referrals to secondary inspection are routine or random. Sometimes officials are checking identity, travel patterns, customs issues, or immigration questions. Most people who think about airport phone searches imagine a dramatic crime story. In reality, many travelers who worry about this are ordinary people who simply did not realize how different border rules can be. There's also a common misunderstanding about geography. People think, I'm in America now, so normal warrant rules must fully apply. Flies. But ports of entry operate under a special legal framework. That is why the customs hall in a U.S. airport does not work exactly like the parking lot outside your office or the sidewalk in your hometown. The location is still in the United States, but Border Authority changes the legal analysis. What about departing the United States rather than arriving? That surprises people too. CBP's directive covers inbound and outbound border searches. So if you are leaving the country, the border search issue is not automatically off the table just because you are not coming in. Now let's talk about what not to do. Do not assume every officer has the same authority. Do not assume a routine TSA checkpoint and a border inspection are the same. Do not assume a dead phone is a clever privacy strategy. It can simply create a travel problem. Do not assume silence alone solves everything. In some situations, refusing to cooperate may bring delay or seizure rather than a clean legal win in real time. And do not assume that because the law is unsettled, the government can do absolutely anything. That is not true either. There are policies, limits, and court decisions that matter. Riley matters. The difference between basic and advanced searches matters. The rule against intentionally accessing cloud-only data matters. The fact that lower courts disagree matters. The fact that citizens and non-citizens face different practical risks matters. Once you see those distinctions, the whole topic becomes much easier to understand. Let's simplify the whole thing into one mental picture. Think of the airport as having different doors with different legal signs above them. At the ordinary TSA screening door, the sign is transportation security. Your phone may be screened as an object. You may have to separate it from your bag. You may have to power it on. The focus is whether the device is safe for air travel. At the international border door, the sign is customs and border inspection. Now the government claims broader authority to inspect devices. A manual search is treated differently from an advanced forensic-style search. The rules are stricter for the government on deeper searches, but the border still gives officials far more room than they would usually have in an ordinary police encounter. At the police door, the sign may be criminal investigation. That is where Riley becomes a major reference point, because police generally need a warrant to search digital content on a seized phone, absent some other recognized exception. Same phone, different door, different rulebook. Once you understand that, the title question becomes easier to answer honestly. Can TSA search your phone at the airport? TSA can certainly screen your phone as part of checkpoint security. But when people worry about someone going through the digital contents of the device, the more important question is often not, can TSA do that? But is this actually TSA, or am I dealing with border officers or police under a different legal framework? That is the question many travelers fail to ask soon enough. And there is one more reason this matters. Airports are high-pressure places. People are rushed, tired, anxious, and eager to get moving. That makes it easy to nod along, hand something over, or answer a question without even understanding who is asking or why. In normal life, you would probably want a moment to think before letting a stranger inspect the most private device you own. The airport environment is designed to keep lines moving, not to give you a law school seminar. So a little knowledge ahead of time goes a long way. If you remember nothing else, remember this. Not every airport phone encounter is a TSA phone search. Sometimes it is just physical screening. Sometimes it is customs at the border. Sometimes it is ordinary law enforcement. Those are different situations, and your rights do not look identical in each one. That does not mean panic. It means precision. If you're flying domestic, the ordinary concern is checkpoint screening, not a deep dive into your digital life. If you're crossing an international border, the legal risk around your phone is more serious and more complicated. If police are involved in a criminal investigation, the normal warrant rule for phone contents becomes critically important. And if you're ever unsure what just happened to your device, document what you can and get legal advice afterward from a qualified attorney, especially if the phone was retained or the search involved sensitive material. Most people do not need to memorize case names, agency manuals, or constitutional doctrine before a trip. But they do need one clear idea. Your phone is protected differently depending on who is holding it and why. So the smartest takeaway is not a slogan, it is a question. Who is asking and under what authority? Ask that question in your own mind before you decide what the airport encounter really means. Because once you understand the difference between TSA screening, border inspection, and a criminal search, you stop being the traveler who is surprised by the rules. You become the traveler who sees the situation clearly, avoids bad assumptions, and knows why this issue matters before it happens to you.